All right, hi everyone. Welcome back. Welcome back. Hopefully, you had a nice weekend. I am almost done grading the midterms. I spent basically the entire weekend doing nothing but that. So I should be done tonight if I get everything finished. Here's the deal. I'll send an email tomorrow for sure, but I think it's gonna be done tonight. You're gonna have to go and pick up your papers from Christina. Okay, she's only there till 5:30 on the dot. Please don't make her stay late. If you can get here a minute too early tomorrow for class, just pick them up. But she won't be there after 5:30, so try and get there right at 5:30, right before. She's on the 6th floor, right across the hall from my office. I can't make her stay late, so please don't make me ask her to. But her hour is till 5:30. I'll have some general notes in the email tomorrow with the exam, but you can go pick them up tomorrow, and we can talk about it in class on Wednesday. Okay? All right. Any questions about the 14th Amendment so far? We've discussed the idea of Equal Protection Clause, due process, privileges or immunities. We've discussed what are Congress's powers to enforce the provisions of the 14th Amendment. Any other questions on this topic? Nothing?
Actually, I do have.
Yes, Michelle.
Why is it there's the privileges or immunities in that clause, but in everything else it's privileges and?
Beautiful question. We don't know. So in Article 4 of the Constitution, it is indeed a privileges and immunities clause. In the 14th Amendment, it's a privileges or immunities clause. I don't know the reason. I've looked into it. There's no good reason why there's a difference. But don't confuse them. In fact, the fact that they're different makes it easy to remember. Privileges and immunity comes first, and A is and privileges or O comes after A. You can remember it that way, but I don't have an answer. I've looked at some length and I haven't found a good answer. Let's see. Any other questions? Okay, so today we're going to be doing one of the more difficult cases to teach. And the reason why it's so difficult is the Dred Scott decision is almost like a how to write a really bad decision. Virtually every aspect of the decision is wrong. And not just wrong as a matter of history, but wrong as a matter of what a court should and should not aspire to. Okay? And I want to show you two pictures. Actually, this came up just yesterday. This is actually a bust of Justice Taney in Frederick, Maryland, where he was from. He was from Maryland. And even today, in year 2015, some hooligans decided to dump a bucket of red paint on the bust of Chief Justice Taney. Indeed, there's always these movements of whether to remove statues of controversial figures. I'll get to that in a minute. But even today, 150 years after his decision, a civil war, segregation, Reconstruction, and everything in between, this one figure, and this happened, I think, like 2 days ago. This is a brand new story. This one figure is still dividing our country. October 11th, so this happened yesterday. Really new story. But the image that most of you think of, or at least you should, when you think of Chief Justice Taney, is this portrait. And it hangs in the Harvard Law School library, and I've actually visited it. And in a decision you'll read later, Planned Parenthood versus Casey, this is an abortion case, Justice Scalia describes this portrait. I want to read you just a second. He says, he's there all in black, sitting in a shadowed red armchair, left hand resting on a pad of paper, right hand hanging limply, almost lifelessly, on the chair. He sits facing the viewer and staring straight out. There seems to be on his face and his deep-set eyes an expression of profound sadness and disillusionment. Perhaps you always look that way, even when dwelling upon the happiest thoughts. But those of us who know the lustre of the great Chief Justiceship came to be eclipsed by Dred Scott cannot help believing that he had the case. It's already apparent consequences for the court burning on his mind. And Scalia was discussing an abortion case we'll get to later, but he's trying to say this empty, vacant look on his face. He knew exactly what he did, and he can't do a damn thing about it. Scalia, of course, was talking about the court's decision in Planned Parenthood where they upheld, where they invalidated certain abortion laws, which we'll get to later. But this portrait is a good one to think about Tawney, because he was trying to do something that perhaps no Chief Justice could conceivably do. He was trying to avert and stop a civil war. He was trying to resolve the most divisive issues that plagued our country, not in the political realm, but in a judicial decision involving this man, a gentleman named Dred Scott. Tawney's aspirations of stopping a civil war could not have backfired more. Indeed, in many respects, it had the exact opposite of its intended effect. In many respects, the Dred Scott decision paved the way for the Lincoln presidency, led to the secession of the southern states, and to the Civil War itself. So beyond the discussion of diversity jurisdiction and the territories clause, which I'm sure you all care a hell of a lot about, right? This decision is a case study of what happens when a court steps out the bounds of what a court ought to do. And it also raises a discussion that has been floating a lot quite recently of whether the Supreme Court has a monopoly on interpreting the Constitution. And for those of you who cheerfully say, of course the Supreme Court has a monopoly on interpreting the Constitution, and of course whatever the Supreme Court says, if there are 5 votes, that makes its law, think carefully about Dred Scott. In fact, there were 6 votes, if my math is correct. 6 votes, indeed. And a guy, congressman, running for president named Abraham Lincoln, said no. Supreme Court does not have the final say on what the Constitution means. The Supreme Court is fallible. And the other branches, the other departments of our government can also decide what the Supreme Court means. And Lincoln said openly, we should ignore Dred Scott. It is not good law. There cannot be slavery in the Northern Territories. Tawney said the government has no power to stop slavery in the territories. Okay? So that's the frame of this case. We'll pivot about halfway through to the 14th Amendment, which was meant to expressly, repudiate Dred Scott. But again, we'll see the Supreme Court effectively said, not going to do it. Not going to do it. And the Supreme Court read the 14th Amendment so narrowly that a law upholding segregated train cars in Plessy versus Ferguson was found valid. And it wasn't much till later, almost 1950s, depending where you count, where the court pivoted and took a different direction with respect to the 14th Amendment. But the first 100 years or so after the Dred Scott decision were very rocky roads. Speaking of which, so tomorrow, that was good. Tomorrow at 11, I nailed it. That wasn't planned either. So tomorrow at 11, the Federal Society is holding an event. I know many of you can't attend, and I apologize in advance. But it's Action on Economic Liberty, and the Texas Supreme Court. Professor Rocky Rhodes will be speaking there. And the topic of this discussion actually involves something we've talked about, which is the idea of do you have a right to pursue a living? And the case are like this. In Texas, everyone know what eyebrow threading is? You take these little threads and pluck out eyebrows. I've never had it done, but I'm sure you can imagine. In Texas, to be an eyebrow threader, the law said you need to be a licensed cosmetologist, which includes hair dyeing and chemicals, all this other stuff. But there's no actual training for eyebrow threading. So the state said, you need to go to school for many, many hours to take a class that will do absolutely nothing to teach you how to be an eyebrow threader. There was actually a challenge in the court system, and the Texas Supreme Court invalidated that law. One of the lawyers who litigated that case will be here tomorrow at 11, so if you can stop by and encourage it. And Professor Rhodes, who clerked in the Texas Supreme Court, will give some comments, and I'll be there as well. Anyway, so back to the rocky roads. So that's the frame I want you to understand Dred Scott from. Tawney, with his sad, sullen eyes, was trying to avert a catastrophe. And he had the hubris to think that a single judicial opinion could unite the nation. And he could not have been any more wrong. Okay. All right, so any questions before we get started? Okay.
Why do you think he thought he was attempting to avert a civil war? Because didn't his opinion actually help you?
He didn't know that at the time, though.
Yeah, but it seems as if doing what he did, he just kind of moved the status quo.
Well, so let me answer Mark's question a little bit of history, okay? In the early years of our country, the most dividing issue, I suppose red state, blue state, right? It looks about the same today. The most dividing issue was slavery. Okay, we had a very small country at the beginning, just on the coast, but there was a vast range of territory that we would expand to. And I'll let this play in the background. This is an animated GIF which discusses how the states expanded. Yeah, it changes. Cool, right? So the question became this. Whenever a state was added, a new state was admitted into the Union, it had a choice. Would it become a free state or a slave state? Okay. This wasn't just an economic question, it was a political question. Because every new slave state had members of Congress who were committed to slavery, 2 senators committed to slavery, and their electoral votes were committed to slavery. And because of the 3/5 clause bonus, right, 3/5 of the slaves were actually counted towards the representation of these states. So when Jefferson acquired what became known as the Louisiana Purchase, which is basically everything over here, there was a big debate. Would these lands become free or slave? And after a while, it kind of went one state free, one state slave, one state free, one state slave. And in 1820, in 1820, there was an arrangement called the Missouri Compromise, where they basically drew a line in the sand. Anything north of this line would be a free state. Anything south of that line would be a slave state. As you can count, there's a lot more land up here than there is down here. And slavery supporters, Roger Taney among them, weren't stupid. They said, listen, if we stick with this line, we're going to have a lot more free states than slave states. Just look at how the map's filling out, right? So this Missouri Compromise was very controversial. And a significant portion of Taney's opinion was rendering it entirely void. So after the Louisiana Purchase by President Jefferson, you have the Missouri Compromise in 1820. Okay? You have a number of these territories up here. And Congress basically said, all the new territories will be free. There will not be slavery allowed in the northern territories. It's funny. Over here it says Northwestern. You know, Northwestern University in Chicago is called Northwestern? So at one point this was the northwestern part of the country. It wasn't much to the west of that, right? So it's called Northwestern. Okay? So the Dred Scott case itself, on a small level, was just about diversity of citizenship. But what makes the decision so egregious is that Tawney went out of his way to basically invalidate the Missouri Compromise and hold that Congress had no power to prohibit slavery. And how he gets there in such a convoluted, contorted fashion is frankly stunning. Okay? So let's start. Where did I finish off last time? Anybody remember? What? Two people just raised their hand. Whoa.
Oh, no, I was pointing.
Steve, you're pointing at him?
I don't care.
All right, well, let's just start up there because I think I took the Onslow last time, so I think Lee's up first. I'll get you in a second, Lee, okay? So the facts of the case are very controversial, very controverted and confusing, but let's try to summarize them very easily. Dred Scott was a slave. He was owned by a Dr. Emerson who worked for the United States Army. And he traveled with his master, if I can use the phrase, from Missouri to Minnesota. Minnesota at the time was part of the territories. It wasn't a state yet. He then traveled to Illinois, the land of Lincoln. Illinois was a state. Scott was allowed to marry, okay, Harriet. This is actually a significant point. Slaves were generally not allowed to marry. They weren't. Indeed, the dissent makes a big fuss about this, saying the fact they married and had a contract means they were citizens. Maybe. But they married, and they had two children. Lizzie, who was born in Missouri, and Eliza, who was born on a boat north of the Missouri line. So at least one of the children was born in a slave state, the other one was not. Okay. There was a way for slaves to sue for their own freedom. So long before Dred Scott, there was a case called Mansfield decision. I'm sorry, the Somerset decision by Lord Mansfield. The Somerset decision. And what the decision basically said, this was an Old English case, the second a slave steps foot on free soil, he is free. And he can sue for his emancipation. Emancipation means your freedom, like the Emancipation Proclamation, you can emancipate yourself. The trick was, could a slave actually sue in a court? Would they actually allow a slave into court? So you'll recall that under the Constitution, in Article 4, there's something called the Fugitive Slave Clause, Article 4, Section 3. Okay? I'm sorry, Article 4, Section 2, Clause 3. And what it says is that no person held in service or labor in one state who escapes, right, needs to be delivered back to the original master. This was one of the provisions put in the Constitution to prevent emancipation. For example, you have the Underground Railroad, right? Slave escapes from Maryland to Pennsylvania, running to the court in Pennsylvania to try and declare his freedom. The state, and in fact, the chief executive of the state, is obligated to return the slave. So this actually inhibits slaves from being able to emancipate themselves. Okay. What happens if it's not a runaway? What happens if a master brings a slave to a free state and keeps him there for a long time? If that slave is able to get to a court, he hasn't escaped, maybe the state court can actually free the slave before he has to be returned. Okay? But that isn't what happens in this case. What happens in this case is that Scott follows Emerson through Minnesota and through Illinois, and then he comes back to Missouri. Okay? Emerson, the husband, dies, and then his wife inherits the slave. Okay? Somehow, not exactly clear, Scott got a lawyer. That was not an easy thing for being in Missouri in the 1850s to get a lawyer. But somehow in Missouri State Court, Scott's lawyer filed a suit saying that because he set foot in the free territory of Illinois and Minnesota, he was now emancipated. Okay? This is discussed in the case, but I don't expect you to understand it completely. But under the law at the time, under Illinois law, he would have been emancipated. And even though he was in a Missouri court, Missouri courts were to apply Illinois law. I encourage you at some point to take a class called Conflicts of Law. It's a very good class, right? What happens if, you know, a citizen of New York and a citizen of New Jersey are in a car accident in Pennsylvania? Whose tort law do you apply? Right? You would probably apply the law of the place where the injury occurred. So you could actually have, though, the suit brought in a New Jersey court applying Pennsylvania law. Okay, this is called choice of law. So here, traditionally, a Missouri court would apply Illinois law. And under Illinois law, Dred Scott was emancipated because he made it to freedom, right? He didn't escape, he made it to freedom. In a case called Scott versus Emerson, which is referenced, it was in your book, the Missouri Supreme Court ruled that we will no longer follow Illinois law. We will apply Missouri law. And under Missouri law, he is not free. The dissent makes a big fuss about it, saying, wait a minute, for 30 years, you guys have been following the law of the other state. Why suddenly are you only following Missouri law? The answer is political, right? They did not want slaves going to other states and getting freedom that way. They wanted to keep the slaves. Okay? So in the Supreme Court of Missouri, Mr. Scott lost. He did not appeal that decision to the U.S. Supreme Court, which comes up a little bit later. Okay, Liam, I'm almost there, I promise. What happens next? Scott, master, Ms. Emerson, sells Scott to Mr. Sandford. Sandford lives in New York. Okay. So now, even though the state courts could not give a remedy, the federal courts could maybe offer a remedy. Lee, what can the federal courts do here? How can the federal courts entertain Mr. Scott's case?
You rely on sometimes screen.
I'm sorry?
Text up on your screen.
No, nothing without on the screen. How can Scott get to a federal court after his master sells him to a New Yorker? Think back to CIFRO. What do you call that thing?
Diversity jurisdiction.
Yes, sir. Diversity jurisdiction. Okay. Defendant or citizen of New York. And Lee, where was Mr. Scott from? Missouri, right. Right. So the defendant was from New York and he was from Missouri, right? Does that get you diversity jurisdiction? But you have two different citizens. And this is the question that Dred Scott presents, right? At its heart, the entirety of the case involves diversity jurisdiction. I know it's a serious letdown, right? Were there actually citizen from New York, citizen from Missouri? The question was, could Mr. Scott have been a citizen of the state of Missouri? Everyone with me so far. So the legal question was really narrow. Really narrow. All the court had to address was whether Mr. Scott was a citizen of the state of Missouri. If he was, then jurisdiction was proper, and they could have sent the case back down to decide if he was emancipated. That was the only issue. And in fact, the concurring opinion, which was like, what, 2 pages long, 3 pages long, basically said that, saying, listen, he cannot be a citizen of the United States because of that, whatever, but that was the original majority decision. But Tawney went back, and you can actually see his handwritten copy here. He had a very nice penmanship, among other things, right? Tawney went back and wrote this very, very broad, convoluted decision which twisted and turned. Okay. So let's start back up top with Jessica. Jessica, let's walk through. I'm going to walk through a couple things, but first let's start with the discussion from Tani. Could a person of African descent ever be a citizen according to Tani? Why? Why can they never be a citizen? Good. Okay, what are those spots? Or give me one of them at least. Good. All right. Well, not 3/5, but you're close. So you're right the first one, right? I'll be precise. The word slavery appears nowhere in the Constitution. Okay? This was not an accident. Those ratifying the Constitution were in a bitter battle over ratification. So compromises were made. So the word slavery appears nowhere. So look at what's called the slave trade provisions, Article 1, Section 9. It says the migration and importation of such persons shall not be prohibited before 1808. Who are these such persons? Well, slaves, but the word wasn't used. Okay. Let's go on to Article 4. No person held to service or labor. Who are these persons held to service or labor? Slaves, right? But the phrase was not used. Okay. So in these two spots, right, the Constitution specifically countenances the importation of slaves as chattel, as property, like Jessica said a second ago. And it also says if a slave runs away, they will be returned back to the state as if they were a runaway piece of livestock. So from this, Tawny says a person of African descent could not conceivably be a citizen, right? Because, Kara, what do citizens get under the Constitution? Bingo. So Article 4, Section 2. Tawny says, all the citizens get the privileges and immunities of the citizens in the several states. So basically, if you're a citizen of New York and you travel to New Jersey, can New Jersey deprive you of various rights? No. They have to treat all the people from out of state as if they were their own local citizens. Tawny basically says it would be insane to think that a slave who travels from state A to state B suddenly gains all those rights. For if that were the case, every single slave who travels would become a full citizen. And the Fugitive Slave Clause, just one provision down, would make no sense. How could it be if a slave goes from state A to state B, he gets all these privileges, but his master can haul him back home? Tawny says that would make no sense. Earl, what does Tawny say about the framing of the Constitution? What status do the Africans enjoy in 1776 or 1787? What status do they enjoy?
They weren't considered to be Jewish.
Yeah. I mean, the Constitution says we the people, right? Are all the people treated equally under the Constitution? Earl? No. No. So Tawny goes like this, right? We have this Constitution that says we the people. We have the Declaration that says all men are created equal. He says, listen, the framers, they were smart people. Could they have possibly meant to include the class of Africans in this? Tawny says, absolutely not. Okay. Now, this part actually isn't true, and this is the point raised by the dissent to a degree. At the time of their independence, at least 5 states granted citizenship to freedmen. Basically, emancipated Africans who were freed were deemed citizens. I don't know if they could vote, but they had some sort of citizenship rights. So Taney's history is a little bit off, right? But his other arguments, right? His other arguments, let's see, Adriana, what's the rebuttal to his other arguments? I mean, did the Constitution actually treat the class of Africans as non-citizens? In other words, is Taney entirely wrong here?
No, that you mentioned.
Yeah, good. So I like the way you framed your answer, right? One of the difficult aspects of this is the Constitution is indeed silent on who these people were. But as a matter of practice, those enforcing the Constitution did deprive these people of a whole life, indeed every right you can conceive of. So Taney basically says, even if a state calls an African person a citizen, as a couple states perhaps did, that is not enough, right? Why is that not enough? Go back to privileges and immunities. Because once a state calls an African a citizen, then they're entitled to citizenship in other states, and that can't possibly be consistent with the Fugitive Slave Clause. You notice everything keeps going back to the Fugitive Slave Clause. The provision that allows a master to bring a slave back to his home state, Taney says, cuts off any argument of citizenship at the head. Okay. So then Taney goes to what the book describes as probably the most racist language in the history of the Supreme Court. And this language was entirely unnecessary. So he uses phrases like the unfortunate race, an inferior order, people altogether unfit to associate with the white race, people who are bought and sold and treated as articles of merchandise. He was using this language very deliberately and very forcefully to try to reinforce his opinion that the Africans could not become citizens, even if they were freed. Why? Let's go back to this map. Oops, wrong way. Let's go back to this map. He was effectively trying to lay the groundwork that even if a state tried to eliminate slavery, they could not do so. That this class of people were so foreign that under no circumstances could they ever be free, even if they were freed by a court. He was effectively trying to undercut the entire abolitionist movement with a diversity jurisdiction opinion. Can you imagine? So we get down to what's effectively the holding of the case. That for purposes of diversity jurisdiction, Scott and other Africans are not citizens. Therefore, they cannot use diversity jurisdiction to get into federal court. Sandra, was that the end of the case? I'm sorry, Maria, was that the end of the case? Did the case end there, like page 4, where it's really easy for you to read? No, he kept going. What was? Why did he stop there, Maria? Why did he keep going? Why didn't he just stop to, yep, not a citizen, case dismissed, no jurisdiction, done? Yeah, and I think the book does a pretty good job treating this, right? He wanted to reach the big picture issue, right? Because Sandra, let me go to you now. Even if say Dred Scott didn't have jurisdiction, right? He wasn't a citizen. What about the next case that's brought up from state court where there was jurisdiction? Right?
He's maintaining that no matter about, doesn't matter about the person jurisdiction.
Yeah.
He's not a citizen whatsoever.
Bingo, exactly right. Taney is like this. Even if we just dismiss this case now for lack of subject matter jurisdiction, next year another case will come by. Next year another case will come by. Eventually, someone with jurisdiction in a state court will get an appeal to the U.S. Supreme Court, and we're going to have to resolve it eventually. Right? So let's take care of this now. right? Let's resolve this now so we won't have to deal with it later. Okay, right?
It's just dicta, though. I mean, did it still operate the same way back then? I mean, it's not a, that's not the decision.
So, I mean, sorry. So your point is this, right? What was the actual holding of Dred Scott? All the case held was that Scott was not a citizen for diversity, right? But the rest of the 30 pages I made you read effectively transformed the nation. Even if you call it dicta, right? People took that stuff seriously. Lincoln took it seriously. Lincoln said ignore the entire opinion.
I guess I'm trying to get Tawny's head, and he knows, what dicta means, and that it's not going to prevent the next person from coming up and still trying.
Oh, he's going to try? Well, let me put it this way. If he rules this way, what do you think the lead will be taken by the lower courts? What do you think the lower courts are going to do? He was trying to send a message to all the other judges. Don't emancipate. Stop freeing these slaves. You can't. These are people incapable of being freed. By their very nature, they are born as chattel. And no judicial act can nullify that. Finish your hand up? Okay. So he doesn't stop here, right? Then he moves on to the discussion of two things. Okay. Was Scott's travel in what was then Minnesota territories, did that render him free? And the second question, were Scott's travels in Illinois, a slave state, did that render him free? Now, before I jump too far into this, he couldn't just do one or the other, right? Because what if he held that, Congress could not eliminate slavery in the territories? Fine. What about Illinois? He had to go the full distance. He had to hold that slavery could not be eliminated. Otherwise, no matter what, Illinois was a state that could pass laws for itself. So the entire discussion about the Missouri Compromise was entirely unnecessary. Because if he couldn't get freedom in Illinois, he couldn't get it anywhere. Everyone get that point. So we start with the Territory Clause. And a provision of the Constitution, which you probably never even bothered to read until now, is Article 1, Section 3. And it says, the Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or property belonging to the United States. So for the first, 50 years of our republic, everyone assumed that this clause meant that Congress could pass laws governing the territories, like all those big boxy states up north, right? And one of the rules passed for the Minnesota territories and Northwest territories was no slavery allowed. Okay, Lindsay, Tawney has a remarkable argument about why Congress cannot use this power to eliminate slavery in the Minnesota territories. What's his argument? It's a stunning argument.
Is it that it jeopardizes the due process of
No. I didn't get to it. Under this clause of the Constitution, right? What is the argument about why Congress cannot regulate the Minnesota territory somewhere up here? Specifically, it's a stunning argument. Yeah.
Minnesota wasn't a state yet,
Good.
so it would be above the line.
No. I thought you had it. You missed it. Kathy, want to do that? No. Mildred? Yeah. Okay, that's right. This is Tawney's argument, and it's a stunning argument. He basically says the territory belonged to the United States. That only affected the territory belonged to the United States in 1787. that the only territory over which Congress could pass rules and regulations was that belonged to the United States in 1787. And any new territory, such as Minnesota, which hadn't been added at that point, Congress had no power over. Earl, was your hand up?
Yes, that's Article 4.
Did I type that wrong? My mistake. I'm sorry. Thank you. Good catch. So I'll have a Constitution handy. Article 4, Section 3. Thank you, Earl. So this is Taney's argument, right? It's almost laughable on their face that Congress would actually need a constitutional amendment to pass any rules governing the new territories. I mean, we had a big map, a lot of land out west, right? That Congress would need an amendment to govern those rules, govern that land. Is that so? Is that crazy? Ooh, why is it not really crazy?
Because if you're, especially for them to be interpreting the Constitution in the manner that they are, you can't speculate. And I personally think that if you're gonna read it word for word and decipher it word for word, then there's nothing in there that speaks about the future.
Good. So there's something called a strict construction. And the idea that, like Lindsay said a second ago, you read every word literally, right? President Jefferson, third president, pretty influential guy, he was faced with a choice. France was basically going into debt, and they gave him a one-time offer. They said, we will sell you the Louisiana territories. And that wasn't just the boot state over here. It was basically everything from Louisiana up to Canada. It was the entire middle part of the country. And Jefferson had basically a very short time to consider it. He did not have enough time to go to Congress for a purchase. And he said to himself, do we have the power to acquire new territory? And reading the Constitution, he said, not really. Jefferson thought, I don't have the power to buy Louisiana territory, but I'm going to anyway, out of what he called the necessity doctrine, right? He said, some things are more important than law, necessity is one of them. Jefferson then went, he got permission from Congress afterwards. But the fact is, Lindsay's not entirely wrong. The Constitution doesn't really say how new territory is being handled. It's kind of silent there. But we'll say this argument's laughable because even if, as a matter of original text, Congress couldn't do that, for about 60 years, Congress had passed thousands of laws governing the territories. Right? Even if the text doesn't get you there, this has been an unbroken practice since before the Constitution was even ratified. Okay, so we'll say that argument's a laugher, right? Yes, ma'am.
Does this, what we're talking about right now, does this go along with the notion that Tony said, because Congress didn't have the ability to establish slavery in those areas, they could not abolish it?
Yes. Say that one more time. I don't know if I wasn't paying attention, but it was a question you asked, but you're exactly right. Say it one more time.
So what we're talking about in relation to his argument that Congress, that the new territory was not established.
Mhm.
So essentially, because they couldn't establish slavery,
Yeah.
in the new territory, they couldn't abolish it.
Yeah, exactly right. Nina's exactly right. So check this out, right? If Congress can't pass rules and regulations to establish slavery in the territories, then conversely, they lack the power to eliminate it. Tawney views slavery as a natural state. It's by birth. They're chattel, right? If Congress doesn't have the power to eliminate it, if Congress doesn't have the power to create it, they can't eliminate it. They have basically no power over the territories. This creates this weird state where the territories cannot be controlled by Congress. And the territories basically have their own little government, but Congress has no power over them. That's a very bizarre proposition because the territories were governed by Congress until they became populous enough to become a state. Yes, Michelle?
But I thought what you were saying was that it was kind of silly for Tawny to even go there with the whole.
As a matter of practice, it was silly.
Because I thought what you said earlier that what it hinged on was the state of Illinois getting down to citizenship.
Ultimately,
Tawny.
yes.
Okay, and then Tawny gets into
But-
who decides citizenship.
But he was also looking at West, right? He was looking at the rest of the map that wasn't covered yet. So he was trying to set not only a precedent for the free states, but saying any new state cannot be a free state. He was trying to do a double dip. Get that? Okay. So first we have the territories. And Tawny basically holds, number one, Congress has no power over them. And number two, because Congress has no power in them, they cannot eliminate slavery in them. And therefore, because they cannot eliminate slavery, number three, Dred Scott was not freed when he passed through the territories. He was not free when he and his wife went through Missouri. I'm sorry, went through Minnesota.
Who did Tawny believe did have power over the territories then? I mean,
This was one of the weaker parts of his opinion. He basically said they were self-governing.
just territories.
Even as territories have provisional governments.
Okay.
As civilized nations, he says, they have provisional governments. And they'll decide for themselves what kind of laws they have.
Correct me if I'm wrong, but doesn't he say that even where Congress has acted with regard to territory, that it falls under the due process?
Ooh, getting to due process 1 minute. Okay. That's my next.
I'm curious how it affects one law is different. But then also some states recognize them as, citizens. And then his apparently allow him to get married. So why wouldn't at least his one daughter be recognized?
That's the final part of the decision. The final part of the decision, which goes back to the first part, is it can't be citizens no matter what. By saying at the outset of the diversity discussion, these people cannot be citizens, even if they're free, even if they're emancipated, they're still not citizens. In other words, there's no way to take an African person and free them at all. That's my decision, that they are by birth bound for life. The daughter born in Illinois doesn't matter. In fact, they got married, makes a difference. This is why the diversity citizenship, he was so hard on that. This is why he's making this point. It's not to say that they're not citizens, it's they cannot be citizens. Not, they could be if they were emancipated under no circumstances. That's why you have this inferior race and this unfortunate discussion.
At some point, he makes an argument where it makes sense to me. He says that they can be citizens of the state, but not of the nation.
Yes, well, what he says is like this. Even if a state calls someone a citizen, they are not citizens for purposes of the Constitution. Even if a state gives a black person the title of citizen, they are not citizens and they do not get the privileges and immunities, because if they did, then the future slave clause would make no sense. See, it's twisted, right? It's very circular.
I think not only is he not saying they're citizens, definitely have them as a person.
Oh no,
It refers to him as property.
chattel, yes.
So it's like you're not even getting to citizenship because you're not even a person.
What are the first three words of the preamble, Toshiba? We the,
I'm sorry.
that's okay.
We the people.
They can't be in that, can they? He has to, at every step of his opinion, exclude the people of African descent from any reference in the Constitution to citizenship or people. That's why he keeps saying chattel, merchandise, property, right? Because they can't be right that we the people. They cannot be in that group, because if they were, this entire thing would crumble apart.
He also,
Yeah, go for it.
he also makes this argument about precedent in Europe, right? That I mean, this is nothing new, but this is the way it's always been in every country in Europe as well. Which,
So, short answer is yes and no. So, slavery goes back to the times of the Romans and Egyptians and Happy Passover. There's been slavery for a very long time. Okay. In 1776, there was Somerset's case in England. The year of independence, the case was decided, saying that if a slave touches free soil, it becomes free. Yeah, exactly. If they breathe the air of freedom, they're free. It's a beautiful image, right? But there was still slavery in all the English colonies, India and elsewhere. So slavery was very much pronounced throughout the 18th century. It was mainly used in the North and South America for various agricultural needs, but it existed elsewhere in the world.
So I know that the opinion
obviously there's no way of getting around what Tony established at that time, but during that time, can you kind of educate me on if a free man married a woman, were the children and the woman considered his property, and then they could be free?
If a freed man married a black woman, you're asking?
Right.
That would probably be cause for a lynching. I'm not being facetious. There were laws called anti-miscegenation laws, which basically did not allow interracial
No,
marriage.
not interracial. Free black man.
Married a slave.
That's like.
The master, I don't speculate too much, but the master of the slave would probably not let that happen. Because the female could not marry without the master's consent.
So if that happened at that point.
It would not be a valid marriage. It would have been obtained under fraud. Because effectively, and not to put too fine point of it, if a free black man took a woman who was a slave, that'd be theft. If he took a wife, that would be theft. And he could probably be hung for that.
And if there was consent.
Then that would be an emancipation.
Okay.
So, I mean, people did emancipate their slaves. So, for example, at George Washington's death, he freed a number of slaves. Most of them were actually martyrs, so he didn't have that many to free, but he did emancipate a number of slaves. And then they can go and do their own, whatever they want. But they have their papers and they have their emancipation papers. But they still want citizens. Not Virginia. Other states, I think Massachusetts had provisions to actually grant citizenship to the freedmen. But again, Tawny says only a state citizenship, not constitutional citizenship, which counts for diversity. Okay. So the next argument, though, and this one is, Caleb alluded to it a minute ago. This argument is pretty intense. So I think I forgot to put it up there. But the Fifth Amendment to the Constitution says, no person shall be deprived of life, liberty, or property without due process of law. Now, we haven't really done much in due process, but we'll get to it before. Oh, so Michelle asked me in the last class, I think, in the 14th Amendment, how come the word liberty has all this meaning, right? This word liberty means freedom of religion, whatever. In many respects, the idea that the word liberty has very substantive components began with Dred Scott. Not exactly, but Dred Scott was one of the first instances where the court effectively said that the provision of liberty in the Due Process Clause of the Fifth Amendment guarantees protections. What is the liberty interest here? The right to own a slave. Tawney explains the Fifth Amendment, among its liberty interests, are the right to own a slave. And you cannot be deprived of that right to own a slave. And for the government to take away your liberty interest in owning a slave is to deprive you of due process of law. It's not that property can be taken away if you're given various procedures. What Tawney's saying is that no amount of process will be sufficient to justify the deprivation of the liberty interest on a slave. The government has no power to take away your slaves. That's the argument. I mean, he just keeps piling one crazy on top of another, right? But he effectively says that the right to own a slave is a substantive liberty interest that the state, the federal government cannot deprive you of. So even if Congress could pass laws in the territories, they could not pass an emancipation law because it would deprive the masters of their property without due process of law. Even if Congress could pass rules in the territories, even if they could not take away a master's slaves, because that would deprive him of due process of law. It would deprive him of a liberty interest without due process of law. This is what became later known as substantive due process. This is a doctrine that goes back all the way to Magna Carta, but this is one of the most famous examples, perhaps infamous examples, where the court recognized a property and a liberty interest in owning a slave. We'll get back to substantive due process later, And often people criticize substantive due process, say, wait a minute, Tawney did it. And I want to say, wait, no. There are other valid uses of this doctrine, right? Of course, reading various constitutional rights that are clearly enumerated. There are valid uses of this. This ain't one of them. This is not a valid use of the doctrine. Doesn't mean the entire doctrine is bunk. I'll stress that point.
I have one question. The 6 other judges who concurred with the opinion, I know we have an additional concurring opinion in here, but do any of them, and I'm sure some of that's cut out, do any of them go out of their way to talk negatively about the language used? Hey, I do concur with the point, but I disagree with the premise. So you have 7 total judges.
Oh, 6 total. 6 total.
I counted 7 because if they have the.
Oh, there were 2 dissents. Yeah. So 7, yeah.
So the other 6 judges, none of them speak out against. Do they share that opinion in essence?
So the book references this later, but among the Supreme Court justices, virtually all of them were appointed from southern states. And among the first, 12 or 13 presidents, virtually all of them were Southerners. So, Roy, it isn't surprising that the majority of the court appointed by Southern presidents from Southern states held these views. All right, any questions on the territories? So basically, Congress has no power over the territories, and even if they could, it would deprive due process of law to take away slaves.
Did Congress, I guess, ignore that ruling, though? I mean, at least, I guess they couldn't have with slavery, I guess. But
What do you mean ignored?
I mean, if they say, if the justice says that Congress, you can't make any rules in the territory, did they just stop making rules in the territory?
What happened a couple years after this decision?
Civil War.
Yeah, we had a civil war,
Yeah.
right? So there wasn't really an opportunity for Congress like, oh, we're not going to follow this. Like half the states basically broke away. We'll get there in a minute. So let's move on to Illinois, right? We're about to free state of Illinois. Did Mr. Scott and his family traveling to Illinois make him free? So this part of the decision is based on something called choice of law, which again I mentioned before, right? Under Illinois law, if a slave came to the state, he could be emancipated. Historically, Missouri followed the site of the emancipation, right? So a Missouri court would apply the law of the place where the emancipation occurred. And if you remember Erie, a diversity court sitting applies the law of the forum state. You guys remember Erie? Yes, usually a court sitting diversity applies the law of the forum state. Okay. The extension of that is we also apply the choice of law rules of the forum state. So a federal court sitting diversity would apply Missouri's approach to Illinois law. Follow that one? Complicated. But because there's no citizenship here, we don't have diversity. So what do we apply? We apply straight up Missouri law. And under Missouri law, as recognized by the Missouri Supreme Court, we do not apply emancipation law from Illinois. Under Missouri law, a slave from Missouri can never be freed. Even though for 30 years, Missouri courts have said we will let the person be freed. In Scott versus Emerson, Missouri Supreme Court said we will never let one of our slaves be free, even if under the laws of a foreign sovereign they should be. This part of the decision was probably correct. I don't say that lightly, but generally speaking, a court is the final arbiter of what its state laws are. And the Supreme Court is usually not in a position to second guess how a state court interprets its own constitution, unless there's a federal constitutional issue in there. Federal courts don't second guess how the state Supreme Court rules. Generally speaking, there are some exceptions. So that part of the decision was probably correct. All right. Any questions on Mr. Tawney? Mr. Tawney with his red paint. You know, I was talking with a friend, and while we were sad about the vandalism, we were happy that people know enough about American history that this is what they choose to protest, right? I mean, they read a case, right? They know something. They know something about American history. So as a ConLaw professor, I'm like, okay, yeah, half good, half bad. Yeah.
He alluded to Congress ignoring it. Essentially, Lincoln said, "Who cares? It's just the Supreme Court." But didn't he know that he was going to get ignored when he wrote it?
Tawney,
Uh-huh.
what do you think?
We're talking about 1857. Lincoln.
Lincoln hadn't been elected.
He would have been 1860.
Lincoln was just a congressman in Illinois at the time. He was no one.
Who was before Lincoln?
Buchanan.
Okay, let's do it.
Buchanan was one of the most failed presidents in American history. Very bad president. Maybe my government teachers can back me up on this one. He was a very bad president. In fact, the book actually references that Buchanan actually lobbied Tawney to write this opinion. The Southerners thought that they could resolve this dilemma through a Supreme Court decision. They sincerely believed that. So to answer your question, did Tawney think it's going to be ignored? No. He thought he writes this like John Marshall before him. I mean, Tawney replaced John Marshall. Talk about filling some big shoes, huh? He thought if he wrote this, everything would be like, all right, I guess we count slavery. He didn't anticipate at all what would happen in the years afterwards.
Further in dicta, I noticed, and I believe you had mentioned previously that the Supreme Court has never said anything about the Second Amendment. And he specifically says Congress can't deny the right to bear arms.
Yeah, what does that mean? Right, yeah, he mentioned the second, mentions right, doesn't explain what that means.
I just thought it was interesting.
I did too.
On this whole rabbit trail of all these things.
He even mentioned quartering of troops.
It was like he was taking a can't talk, I'm still battling this one. A bucket of paint and just slinging it up against the wall.
Red paint, as it were. So that's Tawney. Any other questions on Tawney before we move on to the other opinions? Earl?
I just had a question. Why is there a bust of this guy?
He was from Maryland.
Monumental, or what?
He was a Chief Justice from Maryland.
I know, but do you think that you want to avoid celebrating?
So this is a good point. I'm actually glad you raised it. I was kind of baiting you to raise it, so I'm glad you did. There's a trend nowadays that I find very disconcerting where many people say we shouldn't celebrate people in American history who had bad stuff. In fact, if you know at UT Austin, they just took down the Jefferson Davis statue recently. I have mixed feelings about this sentiment because historical figures are very complex. If we actually take this sort of rubric, then the National Mall in Washington, D.C. becomes very empty. George Washington was a slaveholder. Thomas Jefferson was a slaveholder. James Madison was a slaveholder. Even Abraham Lincoln, if you actually ask him, he didn't really care much about slavery, but he wanted to end the war. Look at the other opinion we have today with John Marshall Harlan. He had this great statement about let the black be free, and he says that Chinaman is not equal. People are complicated. And there was other stuff that Tawney did that was actually pretty important. Decisions which you'll never even read about. One case, which I'll mention briefly, was called Ex parte, was it Merriam or Carl? I can't remember which one. The facts are like this. During the Civil War, President Lincoln, who I think is quite tyrannical, suspended habeas corpus. Okay, he said, I will lock up whoever I want to lock up, and you will not go before a judge. The Union Army locked up a guy in Baltimore, okay, at Fort McHenry. And somehow this guy sent a petition to Tawney, who was the judge for the District of Maryland. And Tawney, by the way, this is probably not true, but this is what the history says. Probably didn't happen this way, but I'll recite it anyway. Tawney says to the general who's running that fort, bring this guy here. I want to have a hearing so if you can have lawful cause. And as it were, the general said, no, I'm not going to do it. Okay. Tawney sent an opinion back saying, I want you, general, to come here and explain why you're not obeying the court order. He ignored it. Tawney sent the final order saying, send a note to President Lincoln explaining why are you ignoring the court. Never did it. So in that limited extent, Tawney actually stood up to what I think was a severe abuse of civil rights. right? I mean, I'm not trying to rehabilitate the guy, but there's a complex history. In that case, who was the bad guy? Lincoln. He's basically locked people up and ignored courts, as he did with Dred Scott. See, this entire thing of ignoring courts can go very far very quickly. Because by the same token, you say, well, I won't obey Dred Scott because I don't like Tony's opinion. What if you're locking people up without a process? Oh, ignore that too. It's a very slippery slope. And I caution people to think very carefully. They say, we should not follow courts, but maybe the decision is so bad you should not follow them. So Tony has some good stuff. And I think he's the only justice from Maryland. I may be wrong about that, but I think he's one of the only from Maryland. So it's unsurprising that his hometown would want to honor him with some sort of bust. Although I don't suspect that will be around for much longer because politically correct people don't like that sort of thing. Other questions?
Not a question, but I think you got it right in the picture up there. I think you did.
Oh, he did it? Why do you think that?
He's kind of smiling.
Anselo, police, what do you think? Is he guilty? You got probable cause searching for red paint? It's like Scooby-Doo, right? Oh, God, look at the two of those damn kids.
There's that bread on this.
I think he's scrubbing it off. I think it's a Maryland hat. Okay. Any other questions on Tawny? Oh, yes, Debbie.
So, and this may get into Nelson, but.
Yeah, go into Nelson if you want. Sure.
Well, I guess my question is, I keep trying to figure out why did not Dred Scott pursue this in Illinois? Right?
How would he have gotten into an Illinois court?
How did he get into Missouri?
He lived in Missouri.
Yeah. But he was in Illinois. I mean, why did he go
Why?
back?
Okay, so why
did
did
he go
he?
back?
He couldn't leave the state. His master wouldn't let him. He was somehow able to get in touch with a Missouri lawyer, and he was able to get into a Missouri court. Unclear how. Oh, it
Why
wasn't.
would he go back? Stay there.
What would Debbie, what would have happened if he stayed in Illinois with his master, didn't let him stay there? Fugitive slave clause. You've been delivered back and probably hung. Runaway slaves were killed. Yeah, it's not so easy to say, yeah, I'll just stay in Chicago for next week. Yeah, it's, nice time for you now. You've been killed.
But to Debbie's point, I think what's interesting about the fact that he didn't pursue legal action until after Emerson died. It wasn't until he became.
So I mean, so in fairness to Scott, it's he had a lawyer who I think was driving this. Scott had no education, these things. So I don't know that he even was aware when he's in Illinois how these laws work. And I'm not trying to be mean to him, but at some point a lawyer found him and said, wait a minute, this guy's our test case because he was in a free state and he was in a free territory. He had a wife, he had a kid who was born in Illinois, right? Or somewhere in the north. This is our case. And they somehow got him to court. Okay. Let's go on to Nelson. Right, so Nelson was originally, yes, it was 7-2, Roy. I'm sorry, I can't count this late at night. Nelson was originally the majority opinion, and he basically said, look, these people are not citizens. Let's resolve this very narrowly as a matter of choice of law, right? Missouri can apply Missouri law, and under Missouri law, he's not emancipated, end of subject. Short 2-page decision, which, although probably, by today's standards egregious, not indefensible, I think the book says. It's not indefensible. There are aspects of that decision which are probably an accurate statement of how choice of law works. But then we go into the 2 dissents. So we have 7-2, right? Crazy vote. And Justice McLean discusses a case, which I didn't sign, but I probably should, called Prigg v. Pennsylvania. Let me describe it very briefly. Pennsylvania basically passed a law saying that Pennsylvania officials are not able to assist with the return of slaves. So as a matter of Pennsylvania law, a Pennsylvania state sheriff or whatever, right, cannot assist in the return of slaves. Supremacy clause. Supremacy clause. This is McCulloch v. Maryland. A state passed a law for the express purpose of frustrating the Constitution. That law is unconstitutional. Pennsylvania cannot prohibit its officers from returning freed slaves. That was the law, right? Let's see what else about McLean I want to talk about. Let's move on to Curtis, right? Because Curtis, I think, makes some of the more powerful arguments. So Curtis says, as a matter of history, it simply isn't true that the Africans were treated as a second class in their entirety. He says in 5 of the 13 states, blacks had some sort of citizenship, that's some sort of franchise, they could actually vote. And he basically describes it like this. Even though, as a matter of practice in every state, the Africans could not vote, the language used, we the people, persons, it doesn't say anything about slavery. It's broader, it's aspirational, and indeed, I think Justice Curtis is trying to say, at some point, like we can live up to this language. There's a great quote. It's a tribute to Martin Luther King, but I'm pretty sure he didn't say it first, saying that the Constitution is like a promissory note, right? It made a number of promises, and it's up to later generations to redeem it. And I think that's somewhat that Justice Curtis is getting at. Look, the language doesn't have any sort of bad language in it. And at some point, we can live up to what the Constitution promised when it said, we the people. Okay? All right. Any other questions on the dissents? I mean, they're mostly self-edifying, but Caleb.
I think Curtis makes a fairly strong point with the Natural Born Citizen Clause.
Oh, yeah, let's talk about that when we talk about it.
Congress having the rule of naturalization, you know, so how does that play into all this?
So the Constitution does not define how one becomes a citizen at all. But the Constitution says to be a member of the Senate, you have to be a citizen for 7 years. Member of the House, a citizen for 5 years. To the president, be a natural born citizen, right? So if the presidency says natural born citizen, it does not say for the other types of offices. How is citizenship granted? Generally by states. States granted citizenship. But Taney says that's not constitutional citizenship. So under Taney's reading, under the dissent's reading, who can ever actually be a citizen of the United States? Basically only white people. That's what Taney says. Right? The only people who are born here that can be citizens are those who are white. Blacks are incapable of ever being citizens. Even if they were natural born, Taney would reply, no, they can't. Even if they're born here, they're not citizens.
Here, Taney's the one that mentioned, I think, the clause 3 there, universal health and service.
Yeah.
So there he has to, I think, he has to kind of admit that they're people. You know, it says no person held in service or labor in one state under the laws.
Good point. Yeah, it doesn't say no chattel held in service. And I think that's what the dissent's trying to get across, right? The Constitution, as it was written, with different people, could have had no slavery, right? No changes have been made to the actual language of the Constitution to prevent slavery. Ultimately, we needed a Warren Amendment to get there, but the language itself is safe. Any other questions on the dissents? So the aftermath of this decision was, I think, into Aaron's question, I don't even think Taney could have anticipated quite how bad it got. But effectively, Taney held that not only were Africans not citizens, not only could Congress make the territories free states, not only would it deprive a person of due process of law to take away their slaves, but that even the free states were not able to emancipate these chattel, right? Taney effectively made it, to borrow a phrase, slavery today, slavery tomorrow, slavery forever. Of course, that's a paraphrase of George Wallace, segregation today, segregation tomorrow, segregation forever. But that's effectively what Taney was trying to solidify, that there would always be slavery because you can't get rid of it. Needless to say, the people, we the people, did not concur So Abraham Lincoln rose to prominence denouncing this decision. And he ran for the Senate in Illinois against Stephen Douglas. And Lincoln lost. People don't remember that part. Lincoln lost the election. Douglas was elected, but I think Lincoln won the presidency shortly thereafter. But Douglas argued that we cannot ignore the Supreme Court. And let me read you a little bit. He says, whoever resists the final decision of the highest judicial tribunal aims a deadly blow to our whole republican system of government. A blow which, if successful, would place all our rights and liberties at the mercy of passion, anarchy, and violence. Douglas basically said, if we start ignoring the court, we pave the way for anarchy. Lincoln replied that Douglas would agree with the court not because it's right, but because it's been decided by the court. And being decided by the court, you're bound. A court decision to him is, thus saith the Lord. Lincoln's like, listen, Roger Taney is not God. This is not gospel. This is not scripture. When he says stuff, that doesn't mean it's right. There's a raging debate to this very day of Lincoln-Douglas, right? Can we ignore decisions of the Supreme Court? Does the Supreme Court have the final word on what the Constitution means? In fact, there was actually a recent statement by a number of professors, not that many, but a number of them, saying that the decision in Obergefell, the same-sex marriage decision, was not legitimate. And they actually called on people to resist the Supreme Court's decision in Obergefell. And they directly analogized Obergefell to Dred Scott. You can agree or disagree with the comparison, but the principle Lincoln said is a principle that simply because the court says something does not mean it's final, does not mean it's right. And indeed, we'll discuss Brown v. Board in a couple weeks, or 2 days, as it were. I have no conception of time. And many segregationists said that Brown was not correct. The governor of Arkansas, in the Little Rock Nine, he said Brown was not right. I will not abide by it. And it took the 101st Airborne, being sent in by President Eisenhower, to make him comply. So the idea of ignoring courts isn't old. It's not going away. And I suspect at some point, in our lives, we may see this again. I mean, just make up an example I've been thinking about. What if the court one day holds there's no right to abortion? There's no constitutional right to an abortion. Roe v. Wade was wrong. 5-4 decision goes the other way. Okay. A person works for the state, provides abortions as a doctor, and she challenges her conviction, saying, no, the Supreme Court decision's wrong. What happens? This is where stuff gets real. As the kids say, the S gets real, right? When you start moving beyond the argument that the court is not final, you're in uncharted territories. And the sort of anarchy, the deadly blow that Lincoln talks about Douglas, becomes feasible. So it's very easy to extol Lincoln and praise him until one considers the implications of taking that doctrine seriously. Now, that's not to say that Lincoln was wrong. I mean, we discussed at great length why the Dred Scott decision was horribly wrong. But at the time, the holding, no jurisdiction, was probably right. The holding itself was probably right. The dicta was disgusting, but the holding itself was probably an accurate statement of the law at the time. Okay. Any other questions on Dred Scott? Anything else on Dred Scott? Yes, sir.
Just had one little comment. It kind of alludes to what Lincoln was talking about, saying "Thus saith the Lord" or whatever. But Curtis kind of closes and talks about one of the decisions made for political reasons that, you just abandon the Constitution. It's just the laws of individual men.
Yeah. So yeah, it's a fair point. So Curtis writes in dissent, Taney's no God. In fact, he's acting like a politician. He set his goal to reach a certain result and twisted and turned to get there. should that sort of decision be entitled to the deference we owe a court. The entire notion of judicial supremacy is also hinged on the fact that judges are acting like judges and not being politicians. And that Tawney, in particular, wasn't trying to avert a civil war with his opinion. Not easy questions, right? These are the sorts of issues that try a nation, and thankfully, one way or the other, things have turned out okay. All these issues have came and went, and we've moved past them. But don't take this up for granted. We don't know the next crisis that will occur. Use an easy example. 2000, we had a case, Bush v. Gore. And I won't bother getting to the merits of the case, but one way or the other, the Supreme Court's decision impacted the outcome of the case. Now, Bush would have won anyway. He had more votes, and every recount would have showed that. But we didn't know that at the time. You can imagine that Al Gore would have said, I will not accept this decision. I don't think it's legitimate. I am the president. Well, crap, what then? Right? What then? There's a concession speech Al Gore gave, and I read a couple of years ago. He basically said, I respect the courts. I will follow it. That's a big deal, right? In other countries, when there's a dispute over an election, people start marching the streets with rifles. We did it in court. And a decision that a lot of people think was wrong, the Vice President Gore stood by, and he complied with it. That doesn't need to happen. That's not a guarantee. In fact, in other countries, we could have had a coup. So fortunately, one way or the other, things usually tend out right, but that's not set in stone, and it may not always happen in the future. Any other case on the Dred Scott? Okay. So we have Civil War. Oh, by the way, Lincoln is elected in a four-way tie, one of which was Stephen Douglas. So the guy who beat him for Senate a couple years earlier, losing the election, shortly after Lincoln is elected, before he's even inaugurated, the southern states start to secede. There's a firing from Fort Sumter in South Carolina, and basically we go into a bloody civil war. And the aftermath of the Civil War, among many things, is a ratification of the 14th Amendment. And we've already discussed the 14th Amendment in the context of the Privileges or Immunities Clause. We said the Supreme Court basically nullified that in the slaughterhouse cases. We discussed civil rights cases. This is where Congress tried to pass an ordinance prohibiting discrimination in various places of public accommodation. And the Supreme Court held that the 14th Amendment only touches state action, that the 14th Amendment only impacts government action, not private businesses. So we move on today to our state action, segregation laws. Okay. And we start with a very brief case. I think, Marco, up to you. The Railroad Company v. Brown. Very brief case. What were the facts there? Really simple case. Guys, conversation? Can I join in? You don't have it? Renee?
The plaintiff, Brown, bought a ticket to a railroad company.
Good.
To use their services, and that railroad company was that railroad company had a grant power from grant power. Well, they had some type of government grant power, and she went to use the white only seats, and she was denied, and basically she ended up having to use the
Okay, good. So the important point here was that when Congress chartered the railroad, when Congress gave the railroad the power or the authority to operate, they provided in their charter that they could not have segregation. That they wrote directly in their charter that they had to have equal accommodations for blacks and whites. That no person shall be excluded from cars on the account of color. This case was not based on the 14th Amendment. It was based on the charter. So what's interesting about this case was that from 1873, 5 years after the 14th Amendment was ratified, the court was faced with this question. Congress said no segregation. They tried to do the old separate but equal trick, right? Have a black car, have a white car, they're both equal accommodations, blacks sit in one, whites in the other, boom. No one's being excluded. Steve, did the court accept that rationale? I'm sorry? That the cars were both separate but equal. Yeah. So the good. So the court writes this. This is a, quote, ingenious attempt to evade a compliance with the obvious meaning of the requirement. And this separate but equal is an ingenious attempt to evade a compliance with the obvious meaning of the requirement. In other words, Congress wasn't being stupid, right? They said no segregation. That doesn't mean have a black car and a white car. That means anyone can sit wherever they want. That's 1873. In 1873, the court is very much able and willing to look at an attempt to enforce segregation through the back door and say, no, that doesn't work. Okay. This was not a constitutional decision. This decision was only based on the charter from Congress. Understand? Between 1873 and 1896 in Plessy, a lot of things changed. Okay? Reconstruction ended. The Union, the northern occupation of the South, more or less drew to a close. And the southern states were left to their own devices to constitute their own governments. And in short order, the southern states enacted what were called Jim Crow laws. And the purpose of these laws were to approximate as closely as possible the state of servitude and bondage that came before the war. They were not able to have all out slavery because that was prohibited by the 13th Amendment, but they instituted sharecropping, various other methods. They were not able to have straight up segregation because the 14th Amendment prohibited that. But they had the idea that, well, if we provide a white car and a black car, a white school and a black school, well, there's equal protection of the law. They both get schools. And I should note, this was not just in the southern states. There was segregation in the District of Columbia. The very federal enclave that passed the 14th Amendment had segregated schools at the time of the Civil War and afterwards. This is going to blow your mind. You'll do Brown v. Well, you did the reading already. When we do Brown v. Board for next class, one of the segregated schools in Delaware. Delaware, whoa, right? Delaware. This was everywhere. This was not just below the Mason-Dixon line. Actually, Delaware is below the Mason-Dixon line, but it's not just in the South. Pennsylvania was the border, sorry. Steve?
This is right around the same time. I need to know that
Tell me what I don't know what that is.
I don't
Good. Well, that makes two of us. Anybody know what that is? History teachers? You want to Google it and tell me? Go for it. Yeah, I don't.
I got it.
Wait, what is it? Yeah.
Compromise 1877. recorded informal unwritten deal that settled the intensely disputed 1876 U.S. presidential.
Oh, Tilden. Right. Okay, so sorry, I didn't get the reference. So there was a disputed presidential election between Hayes and Tilden. There was actually a committee appointed to choose the winner. It was very shady stuff. In fact, there was a Supreme Court justice sitting on this committee. Very, very shady. And as a result of that, the southern states are basically given a lot of latitude to kind of go back on their own ways and do what they were going to do. I think that's what the book's referring to. We have enough AP government teachers to make my life a little bit easier. So let's talk about Plessy. The actual decision in Plessy versus Ferguson, okay? Unfortunately, we don't have a picture of what Homer Plessy looked like. If you Google it, there are all these pictures floating around. They're not him. And I spent hours on this. I can't find a good picture of him. I can't find one I trust. I think Wikipedia has one, but I don't think it's actually him, so I'll pretend it's not. Also making it complicated, there are a couple grave sites with his name on it, so we don't even know where he's buried. A lot of people want to take credit for him and put him in their cemeteries to get attention, but this is probably what his grave site looks like. Here's a plaque in his honor in Louisiana. So I have a bunch of pictures. I've done a lot of research on this case. This is actually his birth certificate from 1863. Okay. There's a sign in his honor. This is Ferguson, though. We know what Ferguson is. Ferguson was actually a judge. Why is the case called Plessy versus Ferguson? In one of the weird kinks of Louisiana law, Plessy was actually suing to challenge the fine imposed upon him by Judge Ferguson. And here's a picture of Judge Ferguson in his virile youth, I suppose. There's his obituary, which makes no reference to Plessy versus Ferguson. Can you imagine? His obituary in the Times-Picayune from 1915 makes no reference to the most important decision of his career. Whatever that's worth, right? All right, so I have here actually, I found a newspaper article, which actually was from the Times-Picayune the day after Homer Plessy was arrested. I'm going to read the headline for you, but I'm going to read the article too. In the wrong coach. A snuff-colored descendant of Ham kicks against the Jim Crow law and takes the jail end of it rather than comply with the distinctive provisions of the law. And let me read a little bit of it, just to give you a flavor. Okay, yesterday around 4:15, Detective Kane arrested from the East Louisiana Adolph Plessy, a light mulatto, and locked him up in the 5th Precinct on the charge of violating the Act of 1890. Okay. Captain Kane, and by the way, Plessy, if I remember correctly, was quite phenotypically white. I think he may have been 1/16th black or 1/32nd black. Basically, I think a black great grandparent. Was it? 1/8? He basically had a grandparent who was black, and he looked white. This was a test case. In other words, Homer Plessy got in this car to get arrested. They were trying to challenge in court this law, okay? And it said basically here, you can read this, that he bought a ticket. They asked him to get up. The conductor asked, "Are you a color man?" Yes was the answer. Then to the conductor, "You have to go to the colored car." The man refused. They said, "If you are colored, you should go to the car set for your race. The law is plain and must be obeyed." At which point they basically arrested him. He was arrested quite deliberately. This was meant to be set up. This was the East Louisiana Railroad Company where he was trying to ride. This is what the train station looked like. I mean, we're talking about almost like a commuter rail that we would think of today. It was a small train. And this is actually the bond that Plessy was released on. He was released on $500 bond. So again, he had a lawyer waiting for him to get arrested. This was a long tradition of civil rights activists who try to get arrested to challenge in court laws that they deem unjust. And this, you can say $500 for the bond. Here's an affidavit that Plessy signed. And this was actually the lawyer for Mr. Plessy. His name was Albion Turget. Okay. This part's actually kind of cool. This is actually the what is it? Great-great-grandson of Homer Plessy. His name's Keith Plessy. And this is like the great-great-granddaughter of Ferguson. Her name is Phoebe Ferguson. And they actually founded a group called the Plessy and Ferguson Foundation, where they try and do various civil rights work in Louisiana. And this is actually, grandnephew. This is Plessy's grandnephew at the train station where his ancestor was arrested. And actually, he called me. I don't know how he found my number, but he randomly sent me an email about Plessy. I was like, yeah, sure. So I talked to the guy on the phone. You know, not a lawyer, but interesting guy, interesting history. I told him a little about the case. And they're trying to, I guess, repair lost time. But let's focus on a darker era first and go back to the actual case. Let's see which picture we stop on. Yeah, I like the mustache. I'll stop here. So recall that 20-something years earlier, the court had basically said the separate but equal doctrine won't fly, right? Not going to fly. It's an ingenious attempt to evade the law. It's clear what equal accommodations mean. What changed in 23 years? The court had once again been appointed by a lot of Southerners, and they realized we need to rule this way. Mark, why do you think the court realized they needed to rule the way they did? And let me ask the question a little bit differently. What would have happened if they ruled in favor of Mr. Plessy? Louisiana in 1896. What do you think would have happened if they ruled in favor of Mr. Plessy?
There probably would have been kind of public violence.
Yeah. Do you think the people of Louisiana would have obeyed this law, this ruling?
No, probably.
Yeah, the same way that segregationists decided to ignore Brown 50 years later. I don't think I'm stepping too far of turn to say that in 1896 Louisiana, if the Supreme Court ordered in a 5-4 decision, you need to integrate your train cars. Mark, you think they would have listened?
No.
So what makes this case difficult to understand is that you're not just reading a piece of paper in a vacuum, right? This was an actual live issue where the justices were probably pretty sure that if they ruled against the Southern state, the court would have been ignored. And then, Mark, what happens if people start ignoring the court?
Then people start to, I guess it's, people start behaving in, I guess, in protest of that.
Yeah, I mean, this is Douglas, right? This is Douglas. You strike a blow towards anarchy. So I'm not saying this to rationalize or justify the court's decision, but you must understand in the backdrop of this case was a simple notion that had the court ruled that Louisiana must integrate, people would have ignored it. Okay? But the flip side to that is, Yvette, by upholding this practice, what did the court do? By giving a blessing to the separate but equal regime, what did the court do? What was the effect of the court's decision? Oh, even worse than that. What was the effect of the Supreme Court ruling in the way they did? Yeah, Aaron, want to take a step?
I was going to say Pandora's box. They essentially gave them a foothold, and they tried to take a mile.
Johnny, you want to add?
Basically legalized the Jim Crow law.
Yeah. The court gave its blessing to Jim Crow. All three of you are exactly right. By ruling in the manner they did, the court institutionalized and gave its blessing to Jim Crow. They basically approved a framework that said on its face it will be separate but equal, but everyone with a brain understood what was going on. So on the one hand, it's certainly true that had the court ruled in 1796 that integration must happen, people have probably ignored it. But on the other hand, by ruling this way, they basically gave a green light to have full-on segregation. And they legitimized this decision by the court saying that it's no big deal for people to be separate, and if it bothers you, it's your own problem. That basically says to people, there's nothing wrong with this. It's like giving your blessing to something bad. You think of the Kawamatsu case we did about a month or two ago, right? Not only did the court uphold the internment, but when the Supreme Court gives its blessing to this sort of action, it makes it legitimate, right? Roger Taney writing how these people were not citizens gave it an air of legitimacy. That's not just some politician saying it, it's now a judge of the Supreme Court. And that has salience, right? So the decision, again, is a two-edged sword. By the court ruling the manner they did, they probably couldn't have ruled otherwise. But at the same token, they legitimized Jim Crow for generations to come. It wasn't until Brown and thereafter that could be stopped.
So what did Railroad v. Brown do?
It was only a statutory case. It was before the 14th Amendment was ratified. There was no constitutional dynamic. This is a case that most books don't even bother mentioning. It was an insignificant case.
In Railroad, they also limited it to the not Constitution, but the Congressional Act, right?
Yeah, it was an act of Congress. It was not based on the
Were they
14th Amendment.
trying to limit that at that time?
Yes. I think that's a good inference. Right? They were making clear that it wasn't about the 14th Amendment. That was only about the act of Congress, the charter. And indeed, it could have been because the ticket was purchased before the 14th Amendment was ratified. It could not have been a constitutional violation. All right, Naquanda, let's go into the actual analysis itself. There are two possible amendments that prohibit this act of segregation, right? You have the 13th and the 14th Amendment. What does the court say about the 13th Amendment? I'm sorry, louder, I can't hear you.
That it doesn't completely.
I'm not understanding what you're saying, I'm sorry. What does the 13th Amendment prohibit?
Slavery.
Is this slavery?
No.
Why not?
Because it's not involuntary.
Okay. The court says here basically that slavery is very narrow, right? This was the civil rights cases, right? Only actual chattel slavery and voluntary servitude amounts to a violation of the 13th Amendment. This discussion of the badges of inferiority that Justice Harlan wrote about, that doesn't fly here. Then we move on to the 14th Amendment, right? Amanda, how does the court understand the 14th Amendment and what it was trying to accomplish?
Well, what I have found, they differentiated from it being by policy, political, to social, and then make a distinction.
Good. Okay. So the court draws a distinction between political rights and social rights. You'll recall we had a case called Strouder v. West Virginia. This was a case where the court said West Virginia cannot exclude blacks from jury duty, right? This, the court holds, is a political right. But what about a train car? What about a school? These are called social rights. And the 14th Amendment does absolutely nothing to protect these sorts of social rights. It only governs political rights. Your question? So you'll recall in the last class I said how the Supreme Court read the 14th Amendment so narrowly. It basically took away any possible protection against private actors.
It says the 14th Amendment's only meant to govern actual slavery, nothing beyond that. And here they take the phrase equal protection of the law. Or is it? Equal protection of the law. There it is. And they say that only applies to political rights. But Sophia, even more than that, though, does the Supreme Court thinks that this law imposes strict racial equality? Does the Supreme Court say that the 14th Amendment imposes strict racial equality? What do you think? What was the holding of Plessy? Was there strict racial equality? What does the 14th Amendment guarantee?
I think they say something like, it's not the government's job to make them.
Okay, very good. So the court basically says this. The Constitution cannot guarantee strict racial equality because the races aren't equal. Basically channeling Roger Taney. The majority opinion says, look, blacks and whites aren't equal. And nothing government can do to fix that. And it's only by the people themselves coming together will we ever actually have equality. Nothing in the government can do that. Not much change from Roger Taney, did it? You can still see the seeds of that language germinating in the Plessy decision, even though Dred Scott was repudiated. Right, but Janine, but isn't it the case though that putting blacks in one cars and whites in another doesn't that make the blacks inferior according to the majority? Yeah, it doesn't make them inferior by putting them in one car of the whites in another, according to the majority.
I don't think it makes them inferior. They're not being denied anything. They're getting equal.
But what if they feel inferior, right? What if they feel left out, that they're being put into the other car? Who's food? Yeah, exactly. Right. The court says like this: if they feel inferior that a black goes into a white car and they can't go in there, that's their problem. Tough, deal with it. Right. That's a stigma they put upon themselves. It's a jarring thought to say the least. But the court has no problem with saying this. They even go far and they have the audacity to say, well, it's equal because a white person can't go into a black car and a black person can't go into a white car. Hell, it's equal. Okay. And this is the majority's reasoning. And the court even holds, but what happens if you have a state and it's elected by a black Congress, right? And everyone in the state's empowers them black and they start oppressing the white people. Well, we can't do anything then. This blinkers reality of the world the court's living in, and it's almost a veil of ignorance that they put over themselves. They say Louisiana, under their police power, can enact reasonable rules, and this is a reasonable rule. They don't say this outright, but it's actually implied. They say this is necessary for safety, because if blacks and whites were in the same rail car, they'll start fighting and there would be violence. It's for their own protection. You'll see this more clearly in the next reading of class.
Wouldn't the argument said that a white person probably would not have been arrested for going into the black
Of course
car?
not. That's why I say there's a veil of ignorance. The court has to pretend that there are all these white guys trying to break into the black cars and they get arrested for it.
I think it's sad that there's a $500 bond. That is way
Judge Ferguson. Well, Judge Ferguson probably didn't think he would make bond, did he?
That's like $13,000.
Yeah. This was a case that challenged the entire existential nature of Jim Crow. Right? This was to the heart of Jim Crow. Judge Ferguson, who's a bitch, didn't even mention this case, was intent on not letting this guy out. Actually, to be fair, I don't know if Judge Ferguson set the bail. I'm not sure about that. But we'll pretend he did for our case. So any other questions in the majority, right? They don't exactly say separate but equal, but this establishes the framework so long as the accommodations are equivalent. right? There's no constitutional injury. Any questions on the majority opinion? You've all probably read this decision or at least heard of it, so the facts are familiar. Okay, let's move on to the dissent by my man Justice Harlan. And you recall in 1883 he dissented alone the civil rights cases. So Cameron, what did Justice Harlan say? What was the point of his dissent?
So the Constitution's colorblind.
Oh, wow, you jumped like 4 questions ahead. Yeah, Harlan writes that the Constitution is colorblind. What does that mean?
It doesn't see races.
Yeah. He says the Constitution does not countenance making classifications on the basis of race. It is indeed colorblind. Right? By the way, not everyone likes Harlan in this one. In fact, when we discuss affirmative action in a couple weeks, people who like affirmative action do not want a colorblind Constitution. They want state actors to consider race. So this aspect of Harlan, but we'll come back to in a couple weeks. Not everyone likes it. But Harlan, decades ahead of his time, says we have a colorblind Constitution. And he says like this, we're not stupid here, right? I know the government's acting under the guise of helping blacks and whites alike, but this is not what's actually going on here. The clear import of the statute is to subjugate, to oppress the blacks. If the government can do this, what else can they do? Put people on different sides of the street, segregate courtrooms. By the way, I never need to kill a mockingbird. Coming soon, right? Separate cars for natives and naturalized citizens. He effectively says, with this logic, every single aspect of society can be segregated. And there's no meaningful distinction, Harlan writes, between political rights and social rights. These are all state action clothed in the color of state law. Okay? Then Harlan, okay, any questions on the part of Harlan that you probably liked? Elizabeth, go for it. Oh. Okay, I'll get there in a second. Any questions on the first part of Harlan's dissent, right? Where he basically says that the Constitution is colorblind and we can't countenance these sorts of discrimination. Okay. So the point Elizabeth raises, I get this every year right around this time, but 5 minutes left in class, is his discussion of Chinese Americans. And one aspect of Justice Harlan's jurisprudence that is hard to grasp is that he viewed the Africans and the Chinese on a totally different plane. So we discussed last week birthright citizenship. Remember we said all persons born here are citizens, bear this language, subject to the jurisdiction thereof. In another case, Justice Harlan dissented and said that Chinese people can never be subject to our jurisdiction because they're so foreign. He said these are people that cannot assimilate and are no part of our national experiment. He firmly believed that Asians could not ever be loyal to the United States. And indeed, it's the same exact xenophobia that pervaded to internment of the Japanese. The exact same sort of fear of foreigners. Because the Africans, for better or worse, they were here. They were Americans. They're part of Americans for generations. But in the late 1800s, the Asians were kind of new. They were working mainly on the railroads out west. People didn't trust them. And for whatever reason, Harlan did not see fit to deem them part of the American body politics. Okay. Second, and I think I mentioned that Harlan taught constitutional law at George Washington, and I transcribed his lecture notes. And he has this great quote, and he says, "If there's a black man who can get ahead of me, I will help him along and rejoice.
And I am glad to feel and know that it is the desire of the white people in this country that the race shall push themselves forward in the race of this life. So he still had very racist overtones. He said the white was a dominant race, but we should help the blacks because, you know, we've kind of put them down. He did not have the same sentiments towards the Chinese Americans. And he did not view them as actually even being able to have birthright citizenship under the 14th Amendment. But I don't want to knock Harlan's dissent, because for 60 years after Plessy, this was the most progressive statement on race in the U.S. reports. The idea that the Constitution is colorblind gave hope to the civil rights marchers, right? And gave hope to people trying to fight segregation. They probably edited out from their speeches the part about the Asian Americans, right? They omitted that part. But even so, people are complex, right? Go back to my my red painted friend, right? People are complex. It's very hard to view anyone in a vacuum, right? You know, people want to take down statues of Jefferson Davis and otherwise, but Woodrow Wilson was a known racist. He was a eugenicist. He believed that various poor people, minorities, should be sterilized. I mean, people have very complex histories, and you have to balance the good with the bad. So I am not taking down my Harlan statue any time, notwithstanding his Plessy dissent. Okay. Questions on Plessy? So what do we have, right? We have Dred Scott. Dred Scott's based on this premise that the black people are inferior, that the whites are superior. We have the 14th Amendment, which is meant to repudiate Dred Scott. What do we get with Plessy? Not too far from where we started from, where even though the institution of slavery was eliminated, for all intents and purposes, Jim Crow resegregated the South. And even the dissent of Justice Harlan, which had a clarion call of a colorblind constitution, still viewed the white race as dominant. And it wouldn't be for many, 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 many more years for the Supreme Court to perhaps catch up with society, perhaps push this society to move away from that lesson. Okay. Questions? Okay, check your emails for tomorrow. I will let you know about the exam, and I'll see you all on Wednesday. Thank you so much. Yes, ma'am.